Welcome to today's episode, where we're diving into a fascinating comparison: the key differences between the Spanish and UK legal systems. Whether you're a law student, a practicing lawyer, or just curious about how legal systems vary across countries, this quick guide will break it all down in simple terms. Let's get started. First up, legal origins. The UK follows a common law system. That means its laws have been developed over centuries by judges through court decisions, what we call case law or precedent. Spain, on the other hand, follows a civil law system. This tradition goes all the way back to Roman law. In civil law countries, laws are mainly written into comprehensive legal codes, and judges apply the law rather than interpret it through precedent. This brings us to our next point: sources of law. In the UK, the main sources are statutes, common law, that is, judicial decisions, and some international or constitutional conventions. Before Brexit, EU law played a significant role too, although that influence is now decreasing. In Spain, the constitution is the supreme law. Then you have the civil code, sectoral legislation, and EU law, which still applies. Spanish court decisions, while important, aren't binding in the same way as in the UK. Now let's talk about the role of judges. In the UK, especially in higher courts, judges can create legal precedent. Their decisions shape how laws are applied in future cases. In Spain, judges take a more restrained approach. Their main job is to apply the code. Past decisions may guide them, but they're not binding. So another judge might rule differently in a similar case. Then we have the legal profession. In the UK, there's a clear distinction between solicitors, who handle client-facing legal work, and barristers, who represent clients in higher courts. In Spain, lawyers are generally known as abogados, and the distinction is less formal. Abogados can practice across different areas, although they may choose to specialize. Now let's look at criminal procedure, a big difference here. The UK system is adversarial. The judge acts as a neutral referee between the defense and the prosecution. Each side presents their case, and the jury, or judge in some cases, decides. Spain uses an inquisitorial model. The judge plays an active role in investigating the facts. They may question witnesses and examine evidence directly, which can make the process feel more investigative than argumentative. In relation to the structure of the courts, there are also key differences. In the UK, cases often start in magistrates' courts or county courts and can move up to the Crown Court or High Court, then the Court of Appeal, and finally the Supreme Court. Spain's structure includes the juzgados, which are the local courts, then the Audiencia Provincial, the Tribunal Supremo, and the Constitutional Court, which focuses on constitutional issues. A final major distinction is precedent. In the UK, precedent is binding. That means lower courts must follow decisions made by higher courts. It's part of what keeps the system predictable. In Spain, previous rulings are considered persuasive, but they don't have to be followed. That gives judges more discretion, but can lead to less consistency in rulings. Lastly, both systems face modern challenges. In the UK, the legal landscape has shifted significantly post-Brexit, and there's ongoing debate about access to justice and legal aid cuts. In Spain, there's a strong push for digital transformation and judicial efficiency. The court system often struggles with backlogs, and there are efforts to better harmonize Spanish law with EU standards. I hope you have now understood the core differences between the Spanish and UK legal systems, different histories, different philosophies, but both constantly evolving. If you want to learn more about the differences between the Spanish and the UK legal systems, please follow us. Thanks for listening, and see you next time.